So in this video, we will be dealing with section 39 to 90, and these sections are very important in practical aspect as well as examination point of view, because these sections are quite easy to remember and understand, but the only point is we have to know the legality behind every provision. That is to say, these provisions may deal with like if there is any evidence that could be primary or secondary evidence before the court of law or before judge, how does he appreciate such evidence? How does he determine the credibility and value of that evidence, and he will incorporate that evidence in his judgment? How does he come up with a judgment incorporating such evidence, whether he relies upon it, right? So these are the aspects that we will be dealing under this particular chapter, that is that covers sections 39 to 90 in new law, but in old law it is section 45 to 90, right? So as we discussed, it comes under chapter 2. So always try to remember, before dealing with any section of any act, we have to read the title of the section, right? Only then we could understand the whole perspective of the whole section itself. So before even dealing with the first section, let's deal with the heading that is given here: opinion of the third person when relevant. So a case is happening uh, before the court, and suddenly a third person who is not at all relevant to the case comes up and gives an opinion. The question is whether that opinion the court considers or not, right? Whether the opinion given by the expert will be relevant with regard to that particular case or not. That is the question here. Him being an expert, him being a third party, when he's a third party, whatever opinion that he gives with regard to the case, that will be relevant. That is the crux of this whole chapter itself, right? So now let's deal with section 39, right? Opinions of the expert, right? What does that mean? When the court has to form an opinion, right? The court has to form an opinion. The court does not have any clarification with regard to any particular field, and it is in need of an assistance from an expert. Like in the field of foreign law, it could be in field of science or arts or handwriting. So in this four field, the court has to form an opinion, but it does not have enough knowledge, or knowledge that is equivalent to the knowledge of the expert, right? The expert has more knowledge than the court, so of course here the court has to rely upon the expert for any sort of opinion. It could be regarding foreign law, science, or arts, or handwriting, that like we discussed earlier. Yeah, only when court needs some assistance from expert and the court lacks knowledge on a certain field of law or certain field of fact, only in such case an expert opinion is relied upon. So now the question arises, who is the expert? And the term expert is not only related to only for these, like, not just foreign law, science, arts, or handwriting. It is in a non-exhaustive list. Like for example, in terms of to assume the deepness of a particular ocean floor, the court has to form an opinion, or it needs some clarity with regard to the depth of the ocean floor. In such case, it might seek the opinion of marine corps or fishermen who used to go and catch fishes, right? That is their they do that in daily basis, so they might know some knowledge about the deepness of the ocean floor. So in such case, the court might seek their opinions. So even that could also be construed under skilled. In such case, their opinion will be construed as a expert opinion, and the opinion given by them will be relevant, right? So there are many case laws that comes under this section. The first is Murari Lal versus State of Haryana, right? So according to this case, and this is a 1980 case, and it is a Supreme Court case. So in this case, it has been held that handwriting science is not perfect, which means the handwriting might change for every 7 years. So that is scientifically proven. For example, if you go to this is a real time example that happens for everyone literally. If you go to a bank and when you make your sign and give the form to the person who is in help desk, he might refuse, saying that the signature is not getting matched, and therefore he gives you one form and you will sign the form again and you will give him back so that he will update the same in his record. So this happens everywhere, like for every 7 years handwriting will change. So it has been held in this case. And so the next case is state versus Dr. Praful Desai. So this is a 2003 case. So according to this case, handwriting includes typewriting, right? For if there is any expert, that is typist, who knows how to type and he has uh, a good knowledge in typing or typewriting, any opinion that is given by him will also be considered as expert opinion. So he will also come under this purview that is held under this case. So this is a recent case, that is Rajesh Bhai Patel versus state of Gujarat. As it is shown here, it is a 2020 case law. So according to this case, it has been held that opinion of an expert is only relevant to the extent that it can be corroborated. So any opinion that is given by an expert is not a conclusive proof, right? It can only be used as a corroborative thing. It only has a corroborative nature. So it is upon the court to decide whether it solely relies upon such opinion or not. It is upon the court's discretion. So basically, it is not a conclusive proof. And next one is opinion of examiner of electronic evidence. It is also the same case where there is a person called examiner of electronic evidence. So he's the expert here. So any opinion that is given by this examiner of electronic evidence will also be considered as an expert opinion, and this is given under the section. So according to section 40, facts bearing upon opinions of experts. Now there is an expert, he gives an opinion. So in his opinion, uh, he supports or denies a particular fact with regard to that case. Whatever he does, he may support it or he may deny it. Whatever it is, it will be relevant with regard to that particular case, right? Let's understand more clearly with the help of the example. So the question is now whether A was poisoned by B or not. That is the central issue. So that is the question now. So what he does is he exhibits certain symptoms like he takes vomit, right? And he goes to the doctor. He goes to the doctor, and the doctor gives his consultation. That is opinion. That if you have a vomit-like symptoms, of course you consumed poison or something. He comes up with such opinion, and now the doctor is playing the role of an opinion, the expert here. So whatever the opinion that is given by the doctor is relevant, right? Of course, he's a medical practitioner, and he may be he may be considered as an expert here, and whatever the doctor says is relevant. According to section 41, that is opinion has to handwriting when relevant. So there is my handwriting, but I'm not able to prove that it is my handwriting. The court should also determine whether it was signed by me or not. So in such case, the court will take heed of this section, right? That is 41. So now the court has to form an opinion whether it was signed by me or not. That is the central issue. It could be both written document or sign as it is. The opinion of the person who has knowledge with regard to the handwriting. Like it could be my friend or even my assistant, any person who has a knowledge about my handwriting. He should have knowledge with regard to my handwriting. That is the only criteria here. So whatever he says, that person, my friend or assistant, his opinion matters. If he says that it is my handwriting, then such opinion given by my friend will be relevant. So now a question rises: how we can prove that that person, the friend, has knowledge or not? He might just be my friend and might not know my handwriting looks like this or that. So now the question is how knowledge is proved. So we have three criteria here. He must have seen the person, any person, not just friend. So any person who has seen my handwriting, right? So basically, if he has knowledge about my handwriting, whatever the opinion that is given by him will be relevant, or any document that is received by him from me. So now I'm drafting a notice with my bare hands, right? So after drafting it, I'm sending the notice to my assistant, and he has to type certain phrases and words. He have to forward it to my client. In such case, soon as I send him my notice that is drafted by me in my bare hands, he sees my handwriting. So he might have some sort of knowledge regarding my handwriting. So whatever he says, he comes up with before the court and says that this is his handwriting, this is my handwriting. When he gives such opinion, that opinion will also be relevant. And now, uh, comes the ordinary course of business. For example, in a written form, I'm sending a letter to my business partner, right? He sends me back his letter. So the recipient who is receiving my letter must have known my handwriting looks in a certain way. And yeah, the same thing, the opinion that is given by him, because he has knowledge regarding my handwriting. He has a specific knowledge that my handwriting looks in a certain way, and he comes before the court and makes his opinion. In such case, his opinions matters, and it is relevant to that particular case. So when any person who comes under any of these grounds, like any of these criteria, if he passes, then we can come to a conclusion that the person is knowledge enough, has a knowledge, right? And he is competent to give his opinion. And there is a very important case law under this section, that is Rathore versus CBI. That is a 2016 case. So what would have been held in this case is that when an opinion that is given by an handwriting expert, and when such opinion is not corroborated, it is very weak piece of evidence. So according to this particular case law, that is the idea. Like when the opinion that is given by the handwriting expert, it should be corroborated, right? But if it is not corroborated, it will be considered as a weak piece of evidence. So next comes the section 41, opinion as to his signature when relevant. So any opinion that is given by the certifying authority, so it is a person here, certifying authority, and the certifying authority uh, issues electronic signature certificate, right, for every person. He issues electronic signature certificate saying that this is yours, and that certifying authority, uh, if in case the court requires any opinion from him, like the certifying authority, he has to provide an opinion, right? The court is seeking his assistance with regard to his opinion. Then in such case, he should give his opinion, the certifying authority. So whatever expert opinion that he gives, the certifying authority will be relevant. As simple as that. So we should only know that there is a person called certifying authority, and if the court requires, his opinion will also be taken into consideration, and the same will be relevant. And next comes the section 42, opinion as to existence of a right, custom when relevant, right? So from the heading itself we can derive an idea about this particular section. So now the court requires an opinion as to whether there was this custom or right or existed or not, right? Whether a custom is there or not, or it has been practiced or not. The existence is itself is the question here. So now the person who has knowledge that this right or custom had existed should come before the court, and he should say that this custom is being practiced for generations after generations, right? But that person should have practiced it. That person should have knowledge about that particular custom or right. Unless and until he has knowledge, he cannot come before the court and give his opinion. And when such person has such knowledge, he can appear before the court and he can give his opinion, and the opinion shall be considered, right? So it is with regard to the existence of any right or custom. So now comes section 43. So the court now has to form an opinion with regard to any usages or tenets, right? So anybody, whether he's a family member or not, and the court has to form an opinion regarding any constitution, government, or any religious or charitable foundation, then any opinion that is given before the court will be relevant. Of course, he or she, the person, should have a special means of knowledge. So now the situation is, we might sometimes witness that a particular term may be used for different meanings in different districts or locality. A certain group of people would be using a term in a different way from the other group. It is the same term only, but different meanings will be there for the term. They will use the term within themselves, right? So to put it basically, a term has different meanings, right? In one place it will be used as a different meaning, and another place it will be used for a different meaning. So in such case, in order to find the exact meaning of a term, any opinion that is given before the court will be relevant. So now comes the next section, section 44, opinion on relationship when relevant. So firstly, exceptions will be dealt in this particular provision. So this is different from other provisions under the law. So firstly, in every law, the meaning, the crux of the law or crux of the provision will be explained. Only then the exceptions will be provided. But in this section 44, firstly, exception is explained, and only then the content comes thereafter. So let's dive into this particular section. So exceptions are as follows, which means these things will not be applied for the section. Perhaps we can say this section will not apply to these provisions. Section 494, 495, 497, 498, all these provisions mostly deal with marriage related offences, also in India Divorce Act. So when one cannot come before the court and provide any opinion with regard to relationships, it will be leading to invading of their privacies. So these are some of the exceptions. So now the court needs an opinion with regard to relationship, with regard to between two individuals or one person to another. There is an opinion that is needed, and the court does not know about the relationship status. Now the family member or even otherwise, it is not necessary that the person who's going to give opinion should be strictly a family member. No, it's not like that. Even any other person, but that person should have special means of knowledge. Only when he has special means of knowledge, he is eligible to give an opinion. Like for example, he could be an husband, wife, brother or sister, right? He should be having a special means of knowledge regarding that relationship. So when he comes and utters any opinion before the court, that will be relevant. And then comes the section 45. So this is a very small section, but it is very important. So as we discussed above, any person who has special means of knowledge in any field can come before the court and give his opinion. But while making such opinion, while uttering such opinion, the opinion that is given should be backed by some grounds, right? Like if I go before the court and say he's that, he's this, I will of course give some grounds as to why I'm saying this. So not just my opinion, the grounds on which I'm relying and I'm uttering my opinion will also be relevant, and the grounds and reasons that I give to come to a conclusion with regard to my opinion is also relevant, and that the court, that will also be considered by the court, not just the opinion.